anybody, last week there was a criminal trial. Jury came back in a criminal trial last week, and I just wanted to know, did anybody see that on TV? Anybody? From Bill Cosby. I wanted to review this a little bit because sometimes we think that, you know, when you look at Bill Cosby, he's one guy, but he's a business. With all of the television shows, the people that are employed, and so when one person goes down, now this is happening at the end of his career, but when one person goes down, I mean, this could be, it could have catastrophic consequences for a business. Bill Cosby is a business. And so when we talked about criminal law, I wanted to just go back over just a few of those things that we talked about with the criminal justice system and how that process has two stages, the investigation stage and then the adjudication stage. I want to lay a little bit of historical foundation so that, because this case has been going on now for a little while, and so it's just taken many legal terms, and some of them can be kind of confusing. And so you have your investigation and your adjudication. So when you have those two steps, you have your investigation and your adjudication, and then now these are the steps that are included in the adjudication, the court side of the action. Once there's enough investigative information to press charges against that person, and charges are actually pressed, then the court case begins.
All right, you know, we're going to be starting a new chapter here today, chapter 4, lawyers and ethics, and I don't know how, but I was able to get some excellent guest speakers to come in and speak with us this evening. I thought I had two. I got one right now. I got Joey Jackson. How many of you all watch CNN? Have you ever seen Mr. Jackson on CNN? You have? No. Okay, well, that's all right. We're going to get to know Attorney Joey Jackson today. He's going to help us out in our discussion on Chapter 4. And before we go into this particular part of lawyers and ethics, or ethics and lawyers, we're going to stop first in the section that deals with the prosecutor. Mr. Joey Jackson, I believe, has some experience as a prosecutor, so that's why I wanted him to speak to us about the prosecutor's role and how it relates to ethics. Because sometimes, you know, you probably don't think that ethics in some ways would relate to lawyers, but I'm going to show you in these sections that we're going to cover exactly how it does relate to the types of decisions that lawyers make. And a prosecutor, sometimes it's called the DA, the district attorney. That is the attorney that represents the state, the people in criminal cases against people. And we're going to talk about a case that is widely known. And before we begin, I'm going to give you a little bit of background if Mr. Jackson would please just give us a few minutes to get caught up on the story.
Absolutely.
And hopefully our next guest speaker, Danny Savalos, will join us in the meantime. But today we're going to talk about the case of Pennsylvania versus Bill Cosby. You all know about that. And so here is a little background on that case, and then we're going to bring Mr. Joey Jackson in to give us his expertise on this case.
We start with breaking news, my exclusive story about comedian Bill Cosby and evidence that I believe jeopardizes the criminal case against him. You'll recall that just a few weeks ago, the famous comedian was finally hauled into court in suburban Philadelphia to face charges for sexually assaulting Temple University employee Andrea Constam. This after at least 50 different women, you see many of their faces here, all had come forward to say Bill Cosby had molested them. I have learned that this case, the only criminal charge that Cosby has ever faced, might soon fall apart. I have obtained a document that no other journalist has that could blow the case up. I talked about it a bit last night on AC 360, but now, new information. So let me back up and tell you the story. Back in 2005, the then District Attorney of Montgomery County, Pennsylvania, Bruce Castor, was investigating Andrea Constad's case. Castor has said he wanted to prosecute Bill Cosby, but believed he did not have enough evidence to sustain criminal charges beyond a reasonable doubt. Still, he thought that Constad might get justice in a civil suit, and he claims he made an unusual deal to create an atmosphere where she could get that justice. The DA told the comedian's attorney, essentially, I won't prosecute your client if you promise that he'll testify fully in a civil case. Cosby's attorney allegedly agreed. It was a deal. In the deposition, Cosby admits he had sexual relationships with at least 5 women outside his marriage, gave prescription sedatives to women he wanted to have sex with, and tried to hide affairs from his wife. Cosby says he gave Constad 1.5 tablets of Benadryl, an over-the-counter antihistamine that can cause drowsiness, to relieve stress. He said that the sex and drug taking were always consensual. Why would Cosby testify so openly? Because allegedly he believed it would never be used against him in a criminal court. The civil case against Cosby was settled, and the deposition remained sealed for many years, but then, last year, a judge decided to release a transcript of it. And the explosive charges Cosby faces now are largely based on that transcript, which we now know could very well be thrown out of court when the case has a hearing on February 2nd. In the last few days, I obtained an email. This email that I confirmed was written by ex-DA Bruce Castor to his successor last year, 3 months before the charge against Cosby. Only those involved in the case have seen this email until now. It's the only clear record of the deal that was made promising not to prosecute Bill Cosby. And here's an excerpt. Castor wrote, I can see no possibility that Cosby's deposition could be used in a state criminal case because I would have to testify as to what happened, and the deposition would be subject to suppression. I cannot believe any state court judge would allow that deposition into evidence. Knowing this, unless you can make out a case without that deposition, and without anything the deposition led you to, I think Cosby would have an action against the county and maybe even against you personally. Bruce Castor has been subpoenaed to appear at the hearing on February 2nd, at which time I believe the case could fall apart.
So now, I can go back to mine. So now, Joey, let me ask the class, was that clear as mud? What's going on where we are now? Are there any questions on where we are now? So that I want you to be kind of having an idea of where we are so that when Mr. Jackson comes in, you'll be up to speed. Yes, sir.
Just in order to make sure I understand it right. The reason in the first place it was brought up was because of what he said in that earlier case, which was then released, and that's why they're bringing up the charges on him. But because the deal was made that they couldn't use that, the case might be thrown out, even to start with, because they shouldn't have to use that to prosecute.
Okay, yes.
Or to bring up charges.
Yes, you're right. So let's fill in the blanks. You're saying that there was a deal made, and who was that deal made by? Right, the prosecutor. And that's why we're talking about this. Because the prosecutor has made a decision in the beginning of this case back in 2005 not to charge Bill Cosby based on the information that he had at the time. All right. Now, Joey, talk to us.
Okay, can you hear me okay?
I can hear you better than myself. Okay.
Good evening, esteemed class. Hope everybody's well. So, here's the point. I was a former prosecutor. Prosecutors have a vast amount of discretion. That is, they can decide to charge, they can decide not to charge, they can reduce charges, they can offer what are called plea bargains, which means they could lessen the degree to which they're charging a defendant in any case. Now, as to Cosby, what is significant here? What's significant is Cosby was under the belief that he was not going to be prosecuted. There was a commitment made between Cosby and his attorneys with the district attorney that he would not be prosecuted for any offenses involving the victim here, Andrea Constant. As a result of him believing that he would not be prosecuted, he went ahead and he gave testimony in a civil case. Now, let's back up 1 minute. Why would someone give testimony in a civil case? Well, because he was sued. There are a number of forms upon which you can go after someone. One is criminally, and that's the province of the district attorney. However, you don't need a district attorney if you're going to go after someone civilly for money. So in this particular case, Cosby allegedly did something wrong of a sexual nature to Andrea Constant. Because the prosecutor was not going to prosecute, she doesn't forfeit her right to sue him for monetary damages to try to collect money. Now, if the impediment for going forward to trying to collect that money was deposing Cosby. What is a deposition? A deposition is when a person sits down and they're asked a variety of questions by attorneys concerning what happened, when it happened, how it happened, who was involved, who were the parties, etc. Cosby would not speak, however, if he knew he was being prosecuted. And so the story goes. The prosecutor said, listen, don't worry, I'm never going to prosecute you. Go ahead in the civil case and tell all you can to Andrea Constant's attorneys. Whatever you know, tell them. None of it is going to come back to bite you. Now, I know that you as a class know and are aware that a person has a right against self-incrimination. It's called pleading the fifth. When you plead the fifth, nothing you say can be used against you because you're not saying anything, so you're pleading the fifth. In this case, Cosby said everything. He gave a deposition where he told about his relationship with Andrea Constant, how many meetings he had with her, what he did with her, what he didn't do with her, the pills he gave her. He talked, okay? Now, the problem here, though, is that he talked relying upon the fact that he would never, ever, ever, ever be prosecuted. What happens? Fast forward years later, and now the district attorney is going after him, and a lot of what they're using against him is his testimony that he gave in a deposition. So he's saying, well, wait a second, I would not have said anything had I known that you would have come forward and gone against me after I talked. You promised me, Bruce Castor, that if I speak in a civil deposition, nothing I say can be used against me. Well, guess what? Years later, there's a new DA in town. And not only is there a new district attorney, but part of that district attorney's campaign promise was that I'm going to prosecute Cosby. If I get elected, he's going to be prosecuted for his abuses against women. Cosby says, well, I thought I was never going to be prosecuted. And if I was, I would have never said anything. The district attorney says, well, we never offered you any immunity. And Cosby says, you most certainly did offer me immunity. That's the only reason I gave testimony. So, curiously enough, in Bill Cosby's prosecution, much of what he said in that deposition is being used against him, which he would have never said had he ever had any inkling that years later, the stuff would have come back and haunted him. And so that's pretty much where we are now. And the legal fight is whether or not everything Cosby said in that deposition can be used or can't be used. Cosby said, I relied upon the prior DA who said I could talk day and night, and nothing I say will ever be used. The district attorney says, that's the old guy, I'm the new guy, and there is no written agreement to give you any immunity, and unless you produce a written agreement, we're prosecuting you and we're using everything you say against you. And that's pretty much where the fight is.
Now, Joey, let me ask you this. Well, let me just start here. Can we also add in the part that Cosby also thought the deposition was going to be sealed? Can you tell us about the piece that went on with the deposition and all of that?
Yes, that's a very good question that your professor raises, and here's why it's a great question. Because there are two layers. Number one, Cosby figured that nothing ever that he said in that deposition would ever be used against him. That's why he gave it, right? He would not have talked. And then the second piece was he was comfortable in speaking not only because he knew it would not be used against him, but because he knew the press would never get a hold of what he said, because everything he said was sealed. That is, it was locked in a box and not able to come out for the press, not able to come out for attorneys, not able to come out for prosecutors, not able to come out for any purpose. When something is sealed, it's locked in a box, and only upon an unsealing order is it now unlocked and everyone gets to see what it says. So now we fast forward, and lo and behold, the deposition becomes unsealed. There was a motion to unseal the deposition. Cosby's lawyer said, how are you going to unseal it? This is something that's locked in a box, and you're not permitted to unseal it. The judge said, well, I'm going to unseal it because you have become a public moralist. You're talking about moral issues. You're talking about being holier than thou, but yet and still, you are engaged in this alleged abusive behavior. So I'm going to let the world see, since you're a public moralist, how immoral you really are. And so the judge unseals this, and since it's now unsealed, the prosecutor is now seeking to use that deposition testimony against him in his criminal case. And so the legal fight is whether a prosecutor can use a deposition that you've given in reliance on a promise not to be prosecuted to ultimately prosecute you, and you put yourself in jail by virtue of the admissions you made in that deposition.
Any questions so far? Because see, we're just beyond that investigation stage, and there's a lot of turning back and forth here in this particular case. But are there any questions up until now? Before, yes, sir.
What year was this?
Okay. 2016. Okay. So that's a great question, because the reason that this is all, you'll see some, well, you did see in that particular video, all of those women, okay? So there's only one woman, based on state law. Each state has their own laws on statutes and limitations. This particular case, this particular thing that happened back in 2005. And so at this particular point, this state's statute of limitation was about to run on that particular case. This DA, it kind of had a political spin. This DA campaigned on the fact that if he was elected, he was going to bring this case against Bill Cosby. And he was in fact elected, and so just like literally days and months before the statute of limitations was going to run, he presses these charges against Bill Cosby, because now he's the new DA, and apparently the legal fight at that time, when this video was made back in 2016, the legal fight was, does he have to uphold the promise from the prior DA? And so I'll get to some of the obviously I'm going to tell you all my opinion, but I'll let you see. Okay, so the trial that we had the jury came back last week, that was the second trial. Okay, the first trial came back as a mistrial, and this is the news from that.
I have a question.
Yes, sir.
Is it true that he doesn't have written proof that he has immunity from the first DA?
Okay, so that's a great question, because that is true. And so that is why that DA was doing the email and back and forth with the new DA. He's saying to him, hold on, because that was the problem. What happened is that when that deal was made, there are a lot of things that just I would never do as an attorney, just never. First of all, if I'm going to make a deal with the district attorney, we're going to have to put it in writing. And that's not something, can you imagine, that he would want to put in writing? I'm letting this big star off the hook, and it's something that you want to say, okay, go ahead, I'll give you my word, but it was never in writing. Okay, so no, the only writing that ever came about was the email from the old district attorney to the new district attorney saying, hey, I had this agreement and I'll testify to what I agreed to. And I still feel like that's still to come, where he says in his email, he says, hey, Bill Cosby could sue you. I'm still waiting for that part of the case. I'm not quite sure what my opinion is on that part. But there's definitely an agreement. And so, no, it was not in writing. In addition, another thing I would never do, I may let my client testify in a deposition, but he's going to be very well prepared. He's going to know once a question comes up, anything about drugs and sex and whatever, it's going to be no thank you and no comment. He just spilled his guts. He just told it all. I see no reason why he needed to do that. And so, at some point, somebody did something, another thing that I would never do. There was some, when attorneys fight back and forth, there was some fighting going on about discovery. So somebody decided that they would file a motion with the court and they would type parts of the from the transcript of the deposition. That's really what we're talking about here. We're really not even really talking about a deposition. We're talking about the parts of the deposition that somehow got into the court's records that the court had to seal once the settlement agreement was entered into with Bill Cosby and Ms. Constead. And so somebody was able to find out that these portions of the deposition were in a court filing that had been sealed. And so this is just a little new snippet from the last trial.
6 days of deliberations, the jury coming back, telling the judge that they are hopelessly deadlocked.
Cosby on trial for 3 counts of felony aggravated indecent assault for allegedly drugging and then sexually assaulting Andrea Constead back in 2004. ABC News correspondent Lindsay Davis is at the courthouse in Norristown, Pennsylvania. Lindsay, what have you learned about the decision? And I guess the big question at this point is, since we know it's a mistrial, will the prosecution retry this case?
Yeah, it's still too early to know at this point. Prior to getting to this place, the prosecution's office had said that they were not going to make that decision immediately. So I think that because we've been in these deliberations now for more than 50 hours, slowly the prosecutor's office was able to see that this deadlock situation was the likely outcome, and they did decide days ago that they were not going to make an immediate.
We're just being told that he has been convicted on all 3 counts. So all 3 counts of aggravated indecent assault, punishable by up to 10 years in prison. Each count, Laura Coates is with us, our legal analyst as well. That would be 30 years if you add them up, but he could serve potentially all of those convictions concurrently.
Yes, in Pennsylvania, for cases like that, you can actually serve. You have 10, 10, 10 concurrently means it's all going to be at once. I have to say, many people are shocked hearing the verdict in this case because this case was so drastically different than the first one. You had the ability to have the civil settlement that was put in place with $3.2 million before the jury this time around. You also had the idea that you had a witness on behalf of the defense team that said that they previously believed and heard Andrea Constead make a statement that she was simply trying to frame a high-profile person at some one point or another. And so this is very shocking. It's not shocking given the volume, however, of the number of people who came forward in the past, and I think it's absolutely right. In this trial, unlike the first one, you were able to hear testimony from 5 other women, in addition to Andrea Constead, who were saying, listen, this is somebody, this happened to me too. Me too has been the phrase that's been used consistently about this case. It happened to them too. And in front of those jurors, they were able to actually hear the words of people who not only espoused the sentiment of Me Too, but actually could say this exact thing happened to them as well. In this case, he was likely to serve the terms concurrently if he is to serve all of the jail time, but sentencing is still out there. Also, we'll want to note that unlike the first trial, where they were trying to paint this as a romantic endeavor, perhaps, and one that was consensual, this time the defense decided to say this was essentially the equivalent of a gold digger based on the civil settlement that obviously did not speak well to the jurors in this case. They did not buy into the notion that it was somebody who was motivated by a financial settlement or otherwise. And now you have this very unique position. The very first time that you have a celebrity, high-profile Me Too case, and really not even half the time of the initial deliberations. This is only a day and a half in.
Now there is one juror who comes forward to, give some information on the jury's opinion.
We move on now to our exclusive interview with one of the jurors who convicted Bill Cosby. 22-year-old Harriet Snyder sat down with Lindsay Davis, and Lindsay, he is convinced he made the right decision.
That's right, no second guessing. Good morning to you, George. Harrison Snyder was the youngest of all the deliberating jurors, and at 22 years old, he wasn't even alive during the height of Cosby's fame. He also admits he wasn't very movement. And while many have said that this case came down to he said, she said, Snyder says for him, it came down to what Cosby said himself.
This morning, a stunning revelation that it may have been Bill Cosby's own words that sealed his fate.
What was the evidence that made you sure, beyond a reasonable doubt, that he was guilty?
I think it was his deposition, really. Ms. Cosby admitted to giving these quaaludes to women, young women, in order to have sex with them.
For weeks, there was speculation about the outcome. But this morning, we hear just what was going on inside the deliberation room during Bill Cosby's retrial, thanks to juror number 1, Harrison Snyder.
But when you entered the room for the first time, were you sure that he was guilty?
No.
So what then made the difference for you once you started deliberating?
Hearing everyone's comments about certain pieces of evidence and going through the different counts.
So you don't feel, even now, that it was an open and shut case?
No.
The 22-year-old says prior to the trial, he didn't know much about Cosby and knew nothing about the allegations against him.
I really didn't know a lot. I knew he was an actor. I knew they did the Cosby Show. I never watched the Cosby Show or anything. I'm a little too young for that.
What did you know about the allegations prior to becoming a juror in the case?
I didn't know anything. I don't watch the news ever. So I didn't even know what he was on trial for.
At Cosby's first trial last spring, the jury deliberated for more than 52 hours, but was unable to come to a unanimous decision on whether or not Cosby drugged and sexually assaulted former Temple University employee Andrea Constand at his Pennsylvania home in 2004.
When Andrea was on the stand, did you believe her?
Yes.
What about those other 5 women who testified?
Yeah.
If you hadn't heard from the other 5 and you just had her word, would that have mattered to you?
I don't think so, because in the deposition he stated that he gave these drugs to other women. I don't think it really necessarily mattered that these other 5 women were here, because he said it himself that he used these drugs for other women.
So you found it to be his words that were the most damning of all?
Yeah.
That's why we say Me Too! While many in the court of public opinion felt the Me Too movement loomed large, perhaps even helping to sway the jury.
Are you well aware of the Me Too movement? Did that have any factor, would you say, in your decision?
No. I really only found out about it after I got home, and then I looked online to see what everything was. I didn't really even know about the Me Too movement.
Snyder describes the jury as being all on the same page when it came to arriving at that unanimous guilty verdict on all 3 counts.
Some have said that I made the right decision, and some people have said that they still think that he's innocent. And I just tell them, if you were there, you would say the same thing. You would say that he's guilty.
Sitting here today, is there any doubt in your mind that you guys came to the right conclusion?
No, I have no doubt at all.
As for inconsistencies in Constand's story, Snyder says that they were explained away by the prosecution's very first witness, a sexual assault expert, who testified in the reporting delays, inconsistencies in statements, and continuing to keep in contact with the perpetrator are all normal behavior for a victim of sexual assault. But Georgie says there was no dissension, no tension at all in that deliberation room. Their verdict was clear.
Pretty clear. Okay, Lindsay, thanks very much. Let's talk about it now with our chief legal analyst, Dan Abrams. Not much comfort Cosby's team can take from this.
No, I mean, defense attorneys like to try and cite what jurors say after the fact, usually ineffectively in an appeal, but this provides no fodder for the defense at all, because he's saying it wasn't the 5 other women, which would be the most controversial issue that was in this case versus the first case that swayed his decision. What I found so interesting is it's a reminder that expert testimony does matter. Right? We always like to say, oh, these experts, anyone can buy an expert, both sides. This guy's making it clear that the expert who testified about what it means to be a victim mattered to him.
Yeah, plus Cosby's words.
Plus Cosby's words, but at least it provided context for him, where when the question was, well, why didn't she report it quickly? Why did it take her a year? Why did she keep calling him after the fact? These are all questions that came up in the wake of the first trial, and this guy's saying the sexual assault expert put it into context for us, first witness.
And so clearly a case of first impression for this juror. Is there anything now that Cosby's team can look to try to get to win on appeal?
Yeah, the biggest issue, and it's not a frivolous argument, is that the 5 additional women who testified in this case about what they say Cosby did to them shouldn't have been allowed to testify. The argument is this is what is called pattern and practice, meaning this was his MO. He did this all the time. That's why the judge allowed it in. Doesn't mean that it's still not a controversial decision. That will be the central appeal.
Thanks very much.
I was reading some things over the weekend that he being Bill Cosby, may not face jail time. That if you look at the judge letting him out, because people thought his bail would be revoked, and it wasn't.
Yeah, I don't quite buy that. I mean, I wasn't surprised that he was released, and I would be very surprised if he didn't serve any time in the context of this case.
Let's see what happens.
Yeah.
Questions about any of that? Okay. So I'm going to point out some things. So this time, the judge let 5 women come in and testify. So you have the 5 women coming in and testify, and then they use deposition transcript in that trial and in this trial. And so I disagree with the expert here where he talks about the biggest issue is going to be the 5 witnesses. I don't think that's the biggest issue. For me, the biggest issue is the deposition, because the deposition is the thing that caused all this to happen. And so I am going to ask your opinion. And here's the question. And I tried to put as many words, I just looked for as many words as I could find, because I want it to encapsulate my disagreement with this verdict, okay? And so do you think, just listen to the whole question, do you think the deposition transcript of Bill Cosby's testimony, this deposition testimony given only after the then prosecutor agreed not to bring criminal charges against him, which was thereafter, this deposition transcript, which was thereafter sealed in a civil case as a result of it was a confidential settlement. A confidential settlement agreement he entered into with Andrea Constead, the same prosecution victim who is the subject of the criminal case, should have been allowed to be used during the criminal trial when Bill Cosby himself invoked his Fifth Amendment right against self-incrimination so that his testimony could not be used against him. Do you think that deposition transcript should have been used? If you think so, go ahead and choose A for yes or B for no. Okay, so I'm going to tell you what I think. I think, well, you know what? Let me clear the room, I'm not going to tell you what I think. So we got, everybody thinks no. The few people who answered think no. Okay, I'm going to finish this one. I'm going to start another one. How many of you think that Bill Cosby is guilty of sexually assaulting Andrea Constead? The one, I'm just talking about the one victim. A for yes, he's guilty. B for no. Yes. Okay. So yeah, I'm gonna tell you what I think. Do I think he did it? Yes. Yes. You have so many women. It's almost as if they will just say the different little things that he would do. He would just do the drugging and the blah, blah, blah. It's the same for all the women, okay? And so I think he did it. But we live in a country where we have laws. Okay, you got to follow the law. You just can't try a person, it didn't work, and then you come back and you say, oh, let me just try some stuff that's not legal to see if I could get a conviction.